from that vehicle? It's my car. I'm just loading groceries. That's a question. I literally just walked out of the store. I can show you a receipt. Don't reach for anything. Then how am I supposed to show you a receipt? You're being. I might need backup. Backup for what? For a federal prosecutor?
Nothing about the parking lot felt unusual that afternoon. A car door closed. A voice issued a routine command. It was the kind of moment that disappears every day without record. Except this one did not. What followed was not chaos, not violence, not a dramatic confrontation. It was something quieter, more procedural, a sequence of decisions made with complete confidence that authority alone was enough. It would later be reviewed, frame by frame, logged, timed, cross-referenced. At the time, none of that was visible. There was no awareness that careers were already in jeopardy. No sign that the city's legal exposure had just been set in motion. No indication that taxpayers would eventually absorb the cost of a single, avoidable choice. The encounter was still lawful, right up until the moment it wasn't. And the record shows exactly when that line was crossed. The first report would later describe the arrest as routine, a brief detention, a standard compliance check in a public parking lot. On paper, nothing about it appeared extraordinary. An officer initiated contact. A command was given. The expectation was immediate submission. There was no raised voice at first, no visible agitation, no claim of danger. Authority was asserted calmly, almost mechanically, as if the outcome were already assumed. What mattered was not the volume of the command, but its finality. From that moment forward, the encounter was no longer shaped by facts, but by certainty. Certainty that the person standing beside the vehicle had no leverage. Certainty that procedure would shield every decision that followed. Certainty that nothing of consequence would come from insisting on control. That certainty was misplaced, because while the interaction unfolded in real time, it was also being preserved. Each instruction, each pause, each escalation that did not need to happen. A record was forming that would later be dissected by attorneys, investigators, and a federal court. The financial exposure was not yet visible. The legal liability had not been named. The outcome had not been announced. But the trajectory was already locked. From this point on, every additional choice would only increase the cost. The woman at the center of the encounter was not unfamiliar with law enforcement. Her professional life had been defined by it. For years, she had worked inside the federal judiciary, occupying a role that demanded restraint, precision, and an uncompromising respect for legal boundaries. As a federal judge, her authority did not come from a badge or a uniform, but from appointment, precedent, and the written record of the law itself. Her decisions shaped sentencing outcomes, civil rights rulings, and constitutional interpretations that extended far beyond a single courtroom. Colleagues described her as methodical, deliberate, uninclined toward confrontation. Her reputation was built on procedural discipline rather than ideology, and on an insistence that power, when exercised, must always be justified on the record. Outside the courthouse, her life was deliberately unremarkable. No security detail, no expectation of special treatment. She lived within the routines shared by millions of Americans, moving through public spaces without identification of her position or status. That normalcy was not accidental. It was a principle she adhered to. On the day of the arrest, she was engaged in one of those ordinary routines. There was no public appearance, no legal proceeding, no professional obligation unfolding in the background. She was not acting in an official capacity, nor invoking her role. She was simply present, complying with the rhythms of daily life. What would later become central to the case was not who she was in the abstract, but what she represented within the legal system. Her career reflected a consistent adherence to process. Her record showed no disciplinary actions, no ethical controversies, no history that could plausibly justify suspicion or escalation. In the months that followed, these facts would matter. They would be introduced not as character references, but as context. Evidence that the encounter did not involve a marginal figure or an ambiguous actor, but someone whose professional identity was inseparable from the rule of law itself. This grounding would strip away alternative narratives before they could take hold. When the encounter escalated, it would not be against a backdrop of uncertainty, provocation, or risk. It would unfold against the established credibility of a person whose career had been built on respecting limits that others were sworn to enforce. The parking lot itself offered no warning. It was open, well lit, and unremarkable. Vehicles moved in and out without interruption. People passed through without drawing attention. There was no emergency, no disturbance, no call for heightened caution. She had just finished loading items into her vehicle. The process was slow and routine, marked by small pauses and ordinary gestures. Keys were visible. The car was stationary. Nothing about the scene suggested urgency or threat. When the officer approached, the initial interaction carried the tone of procedural normalcy. A presence, a question, a request framed as routine. This was the point at which countless lawful encounters begin and end without consequence. She responded calmly. Her movements were measured. There was no attempt to leave, no raised voice, no refusal to acknowledge instructions. The setting remained controlled, public, and visible to anyone nearby. At this stage, the law imposed clear limits. There was no probable cause articulated, no allegation of a crime in progress, no behavior that would justify detention beyond brief inquiry. The encounter remained, by all observable standards, within constitutional bounds. What followed was subtle, a shift in posture, a change in tone, an assumption that compliance was owed rather than requested. The officer's commands became more directive, less explanatory. The language no longer clarified purpose. It asserted authority. Each instruction carried an implicit expectation that questioning itself was inappropriate. Still, there was no disruption, no resistance. The moment remained ordinary enough that it could have ended at any time without incident or record. That was the final off-ramp, because once the interaction moved beyond inquiry and into control, the ordinary protections that governed brief public encounters began to erode. What had started as a routine presence became a test of dominance. What had required justification began to rely on insistence. None of this was visible to bystanders. None of it registered as dramatic in real time. But in hindsight, this was the last moment when the outcome was not yet fixed. Every lawful option still existed. Every safeguard was still intact. The next decision would determine whether those safeguards remained in place or whether the encounter would enter a legal trajectory that could not be reversed. The escalation did not arrive suddenly. It unfolded in increments small enough to appear procedural. The officer's requests were no longer framed as questions. They were delivered as directives, each one narrowing the space for lawful disengagement. Identification was demanded without explanation. Movement was restricted without justification. The tone hardened, not through volume, but through insistence. At this stage, the interaction had already departed from its original purpose. What had begun as a brief, undefined inquiry shifted into an exercise of control. The legal threshold for detention had not been articulated, yet the practical effect was unmistakable. Compliance was no longer optional. She remained composed. Her responses were brief and measured. She did not raise her voice or challenge authority in the way popular narratives often depict. Instead, she sought clarity. What was the basis? What was being alleged? These were not confrontational questions. They were procedural ones. They were not answered. The refusal to explain became the first point of fracture. Authority was asserted without reference to cause, and when that authority was met with calm inquiry, it was treated as defiance. The officer's posture shifted closer. The physical distance closed. Control was being reasserted through proximity rather than reasoning. Each step followed a familiar pattern. A directive was issued. Compliance was expected. When compliance did not arrive instantly, the instruction was repeated with greater finality. The language of procedure masked the absence of legal foundation. This is how escalation often functions in practice, not through overt aggression, but through momentum. Once control is asserted, backing away requires acknowledgement that it was unnecessary to begin with. That acknowledgement did not come. Instead, the officer introduced consequences. Detention was implied, non-compliance was suggested. The encounter was reframed as one in which enforcement was already justified, even though the justification itself had never been stated. Bystanders remained at a distance. The scene still lacked drama. There were no drawn weapons, no raised voices, nothing that would attract immediate intervention. To an untrained observer, it could have appeared unremarkable. But within the framework of constitutional policing, the shift was profound. The moment restraint replaced inquiry, the officer assumed obligations that were not met. The obligation to articulate cause, the obligation to limit scope, the obligation to disengage when justification could not be established. None of those obligations were fulfilled. Instead, the officer continued forward. A decision was made to detain. Physical control was applied. The logic of enforcement overtook the logic of legality. From that point, the outcome narrowed rapidly. The arrest was no longer a response to behavior, but the culmination of an assertion that had gone unchallenged internally. Once initiated, it carried its own momentum. Paperwork would follow. Charges would be listed. The record would reflect a narrative constructed after the fact. What did not change was the absence of a lawful basis at the moment control was imposed. This is the inflection point courts later scrutinized most closely. Not the final act of restraint, but the sequence of decisions that made it appear inevitable. The failure to pause, the failure to reassess, the failure to disengage when escalation served no legal purpose. By the time handcuffs were applied, the legal exposure was already severe. The arrest itself was only the most visible consequence of a chain of earlier choices. At that moment, none of the future ramifications were apparent. There was no mention of civil liability, no awareness of the evidentiary record being created, no indication that the encounter would later be reviewed beyond internal reporting. But the system had already begun to respond. Every command issued without cause, every refusal to explain, every escalation that replaced judgment with insistence. All of it would be preserved, and all of it would matter. By the time the arrest was formalized, the legal framework governing the encounter had already been violated in multiple, traceable ways. What mattered next was not outrage or perception, but sequence. Courts do not ask whether an interaction felt unfair. They ask when authority exceeded its lawful scope. The first checkpoint occurred at the moment initial contact shifted from inquiry to control. In public spaces, officers may approach and ask questions without cause. The moment compliance is compelled, however, the standard changes. Detention requires an articulable reason tied to specific facts. That reason was never stated. The second checkpoint emerged with the demand for identification. In jurisdictions where identification may be required, the obligation arises only after lawful detention has been established. Absent reasonable suspicion, a refusal to provide identification cannot, by itself, justify escalation. Here, the demand preceded any lawful basis for detention. The third checkpoint involved movement restriction. Preventing a person from leaving, even briefly, constitutes a seizure under constitutional analysis. That threshold was crossed quietly, without announcement, and without explanation. From that point forward, the encounter required justification that was never supplied. This is where many citizens make unintentional errors. They assume that questioning authority escalates risk. They assume compliance will shorten the encounter. In reality, compliance cannot retroactively legalize an unlawful detention. Courts examine the officer's justification at the moment control is asserted, not the subject's behavior afterward. As the encounter progressed, the absence of lawful grounding compounded. Each additional command relied on the authority of the previous one. This stacking effect creates the appearance of legitimacy while masking the original defect. By the time arrest is initiated, the foundation is already compromised. Another critical checkpoint involved the characterization of resistance. Nonviolent, verbal disagreement does not constitute obstruction. The law draws a clear distinction between refusal to comply with unlawful orders and active interference with lawful duties. That distinction would later become central to judicial review. What courts evaluate in these cases is consistency. Was the officer's conduct aligned with constitutional requirements at each stage? Was there an opportunity to disengage once justification could not be articulated? Did the officer reassess or simply proceed? In this case, the record showed continuity of escalation without legal recalibration. The absence of cause at the beginning infected every subsequent action. No later development cured that defect. By the time the arrest was completed, the legal outcome was already constrained. The question was no longer whether the detention would withstand scrutiny, but how much exposure it created. Civil liability does not arise from isolated mistakes. It arises from failures to correct course when boundaries are crossed. These checkpoints would later be reconstructed with precision. Timelines would be aligned, language would be examined. What mattered was not intent, but compliance with established limits. The law does not demand perfection, it demands restraint. And in this encounter, restraint had been abandoned early. The turning point did not come from testimony or interpretation. It came from record. Video footage captured the encounter in uninterrupted sequence. Audio preserved tone, timing, and the precise language used at each stage. There were no gaps large enough to obscure context, no missing intervals that require reconstruction from memory. What occurred was preserved as it happened. When investigators later reviewed the material, the narrative presented in initial reports could not be sustained. Commands that had been described as routine appeared unsupported when played back in real time. Moments labeled as resistance were revealed as pauses. Requests for clarification were recorded exactly as they were spoken. What mattered most was not a single frame, but continuity. The footage showed when inquiry became control. It showed the absence of explanation at the precise moment explanation was required. It showed escalation occurring without any corresponding change in circumstances. The visual record did not dramatize the encounter. It documented it. Audio analysis proved equally consequential. Tone remained measured on one side. On the other, it hardened without justification. The absence of threats, flight, or physical aggression was not inferred. It was audible. Once this material entered formal review, discretion narrowed. Internal investigators could no longer rely on summaries. External counsel could no longer speculate. The evidence spoke without amplification. What followed was procedural. Timelines were synchronized with dispatch logs. Department policies were overlaid against the recorded conduct. Legal standards were mapped to specific timestamps. Each decision was evaluated in sequence, not in isolation. This is where authority lost its flexibility. Once conduct is preserved, interpretation gives way to comparison. The question becomes binary. Did the action align with policy and law, or did it not? In this case, the divergence was consistent. The evidence did not reveal malice. It revealed certainty. Certainty that authority did not need to justify itself in real time. Certainty that procedure would absorb deviation without consequence. That assumption collapsed under review. By the time external legal counsel assessed the case, liability was no longer theoretical. Exposure was measurable. The risk assessment shifted from defense to mitigation. What could not be undone was the record itself. It existed independently of intent. It did not respond to explanation. It simply showed what occurred. This is the point at which many cases resolve, not because wrongdoing is admitted, but because it can no longer be credibly denied. Evidence eliminates ambiguity. It narrows outcomes. From that moment forward, the trajectory moved away from debate and toward accounting. The question was no longer whether the city would respond, but how much the response would cost. The authority that once felt absolute now operated within constraints imposed by its own documentation, and the system began to correct itself. As the case moved beyond the initial review, attention shifted away from the single encounter and toward the structure that allowed it to unfold without interruption. The question was no longer limited to one officer's decisions. It became a question of oversight. Internal records revealed that the conduct captured on video was not anomalous. Prior complaints had followed similar patterns. Stops initiated without clear articulation, escalations justified retroactively, reports that relied on broad language rather than specific facts. None of these incidents, taken alone, had triggered sustained intervention. Supervisory review processes existed, but they functioned reactively. Complaints were assessed in isolation, without cross-referencing patterns or identifying repetition. Each incident was treated as a discrete event rather than a data point within a larger behavioral trend. Training materials emphasized compliance and command presence, but offered limited guidance on disengagement. Officers were instructed on how to assert authority, but not on how to relinquish it when justification dissolved. This imbalance created a structural incentive to continue encounters rather than reassess them. Policy language reinforced this dynamic. Procedures prioritized officer discretion while deferring accountability to after-action review. In practice, this meant that escalation could proceed unchecked in the moment, with consequences addressed only if external scrutiny followed. That scrutiny did not arise internally. It came from outside the department, from legal counsel obligated to assess risk rather than loyalty, from federal standards applied without deference to internal narratives, from comparison, not explanation. When patterns were aligned across prior incidents, the similarities became difficult to dismiss. The same procedural shortcuts, the same reliance on vague justification, the same resistance to de-escalation once authority had been asserted. None of these findings required speculation. They were drawn from documented encounters, policy language, and training records. The failure was not hidden, it was normalized. Crucially, the system did not require malicious intent to produce these outcomes. It required only tolerance. Tolerance for unchecked discretion. Tolerance for minimal review. Tolerance for outcomes that did not generate immediate liability. This case disrupted that tolerance. Because the subject of the arrest occupied a position that ensured review would be exacting, legal analysis would not rely on departmental summaries. It would rely on standards the department itself claimed to uphold. The exposure was therefore broader than a single claim. It implicated supervisory practices, training priorities, and the mechanisms by which accountability was deferred rather than enforced. By the time these issues were identified formally, they could no longer be framed as individual lapses. They reflected a system that permitted escalation without consequence until documentation made denial impossible. This distinction mattered. Courts do not require proof of conspiracy to find systemic failure. They require evidence that safeguards existed on paper but failed in application. Here, that evidence was present. The case had moved beyond discipline. It now implicated governance. And with that shift, the potential consequences expanded accordingly. Once the case entered formal litigation, discretion narrowed further. The question was no longer whether the encounter reflected poor judgment, but how the law would assign responsibility for it. Civil proceedings do not weigh intent. They assess exposure. Depositions began with the same footage that had already reshaped internal review. Each question returned to timing. When was the decision made to detain? What facts justified it at that moment? Why was disengagement not considered once justification could not be articulated? Answers varied. The record did not. Department representatives attempted to frame the encounter as a series of reasonable judgments made under uncertainty. That framing failed when measured against the preserved sequence of events. Uncertainty requires articulation. It requires facts. The evidence showed none that satisfied constitutional standards. As discovery progressed, the city's legal posture shifted. Motions focused less on dismissal and more on limitation of damages. Risk assessments were updated. External counsel advised that proceeding to trial would amplify exposure rather than contain it. This is the point at which many municipalities reassess priorities. Litigation is not only about prevailing, it is about cost control. When liability becomes probable, resolution becomes strategic. Settlement discussions followed. The figure that ultimately emerged did not reflect symbolic accountability. It reflected calculation. Attorneys evaluated comparable cases. They assessed jury behavior in similar jurisdictions. They factored in the professional standing of the plaintiff and the clarity of the evidentiary record. The amount $820,000 was not arbitrary. It represented the estimated cost of taking the case to verdict and losing. It reflected legal fees, potential damages, and the reputational impact of adverse findings. It was, in effect, a recognition that the city's position was no longer defensible. The resolution did not include an admission of wrongdoing. Civil settlements rarely do, but it did include acceptance of consequence. Funds were allocated, claims were closed, the matter was recorded, parallel administrative actions followed. Employment status was reviewed, certifications were evaluated. Internal policy revisions were initiated, not as reforms driven by introspection, but as responses to exposure. The system moved as it always does, slowly, procedurally, without spectacle. What made this outcome significant was not its visibility, but its finality. Once entered, the settlement could not be undone. It became part of the city's legal history. It would be referenced in future risk assessments. It would inform training revisions. It would appear in disclosures. The authority exercised in that parking lot had carried consequences beyond the moment, not because of outrage, not because of protest, but because the law required an accounting, and that accounting had now been completed. The resolution of the case did not generate public spectacle. There were no demonstrations, no viral statements, no sustained media cycle. Its impact unfolded more quietly, within institutional processes that rarely attract attention unless disrupted by force. Policy revisions were drafted with careful language. Training modules were adjusted to emphasize articulation, disengagement, and documentation. Supervisors were instructed to identify patterns rather than isolated complaints. None of these changes were framed as admissions. They were framed as risk mitigation. That framing was deliberate. Municipal governments respond most consistently not to criticism, but to exposure. When a single encounter produces measurable financial consequence, it alters how future encounters are evaluated. Costs are tracked. Patterns are flagged. Behaviors, once tolerated, become liabilities. Within the judiciary, the case served as confirmation rather than revelation. The legal principles applied were established long before the encounter occurred. What changed was their enforcement. The record provided a clear example of how routine authority, when unchecked, becomes actionable. For civil rights practitioners, the case reinforced a familiar truth. Accountability rarely arrives through confrontation in the moment. It arrives through documentation, sequence, and procedural review. Evidence does not need to dramatize misconduct. It only needs to preserve it accurately. The settlement figure would be cited in subsequent negotiations, not as precedent in the formal sense, but as reference, as an indicator of how similar conduct had been valued, as a benchmark for exposure. Most importantly, the case reaffirmed the function of the legal system itself. Authority may act quickly. Oversight moves slowly, but once engaged, it is cumulative. It absorbs records. It compares actions against standards. It assigns consequence without regard to status. The parking lot where the encounter occurred returned to anonymity. Nothing marked it as significant. No plaque recorded the outcome. What remained was the record. A record showing precisely when authority exceeded its bounds. A record showing how evidence shifted power. A record showing that the law, when invoked through its proper channels, does not need urgency to be effective. It only needs time.